That concludes my remarks. Thank you for the opportunity, and I'm happy to answer any questions you may have.
Thank you very much, Mr. Fuentes. I'll now recognize our third witness, Mr. Mike Saunders. Mr. Saunders is the Director of Military and Consumer Policy at Veterans Education Success. Subcommittee thanks you for appearing here today, Mr. Saunders, and you have 5 minutes.
Chairman Pappas, Ranking Member Bergman, and members of the subcommittee, thank you for the opportunity to provide input on VA overpayments and debt collection procedures. Veterans Education Success is a nonprofit organization that provides free counseling and legal assistance to students using their GI Bill and military education benefits and works to advance higher education success for all military-affiliated students. We greatly appreciate the subcommittee's attention to this very important issue, and I'd like to thank the VA for their recognition of the problem, but action is required. We have helped approximately 5,000 veterans with GI Bill problems. We have seen a recent uptick in the number of military-connected students who are experiencing VA clawbacks of their hard-earned GI Bill, giving us a first-hand view of how opaque and, frankly, Kafkaesque the process can be. Veterans' complaints largely fall into 2 main overpayment situations: overpayments for a dropped class and retroactive readjustments of GI Bill benefits awarded to a veteran. GI Bill overpayments warrant this subcommittee's attention. A 2015 GAO report found a startling 1 in 4 post-9/11 GI Bill students experienced GI Bill overpayment. According to GAO, 90% of GI Bill overpayments are caused by veteran enrollment changes. The problem is that VA disperses the entire term of post-9/11 GI Bill benefits after a veteran sits for just 1 day of class. If students drop out or drop a class after the first day, the school still gets the tuition and fees for the entire term. This incentivizes some unscrupulous college recruiters to lie to veterans to get them to enroll, knowing the student will likely drop out quickly. Worse still, VA comes after the veteran for the overpaid tuition, even though the tuition never touched the veteran's hands, but was sent straight to the school. This defies common sense. Students are being asked to come up with tens of thousands of dollars that they don't have and never touched. In contrast, the U.S. Department of Education delays disbursement until after the typical college add-drop period and claws back tuition from the school, not the student. We thank the Subcommittee on Economic Opportunity and many members here today for working with us to solve this through the bipartisan Forever GI Bill Class Evaluation Act, which would delay GI Bill disbursement until after the typical add-drop period, and the bipartisan Student Veteran Empowerment Act, which would require VA to verify post-9/11 GI Bill enrollment on a monthly basis, as it already does for the Montgomery GI Bill, rather than waiting until the end of the semester. Another problem we urge the subcommittee to address is retroactive readjustment of education benefits. One case brought to VES involves a beneficiary who had the post-9/11 GI Bill transferred to her by her father, who was assured by his personnel office that retiring 33 days before the end of the 2-year service obligation he incurred for transferring his education benefit would not affect that benefit transfer. VA approved her GI Bill and she went to college. Nevertheless, 7 years after her father retired and 6 years after she graduated, VA sent her a debt collection notice stating that she owed up to $100,000 and that they were also going to restore her father's education benefit, in clear contravention of the wishes of the family. If a veteran lied to VA, then VA should go after the veteran. But VA administrative errors are not a veteran's fault. If VA certifies a student's eligibility, it can't ask for repayment 6 years after the student relied on VA's approval and graduated. Now, turning from GI Bill specifics to VA's overall debt collection practices, we have identified a number of critical problems we hope the subcommittee will address. First, VA's aggressive collection tactics are on their face in opposition to VA's emphasis on serving those who have committed to defend us. For example, GAO found that VA collects nearly all its debts by withholding a veteran's other benefits, such as withholding entire disability payments. If you take that much needed money, veterans have to choose between paying for food, medicine, or housing. Importantly, VA's regulation calling for aggressive debt collection goes well beyond what is called for by statute. We urge the committee to require VA to bring its regulations in line with statute and to also forbid VA from taking more than 25% of a veteran's benefits to cover unrelated debts to VA. Second, VA's aggressive debt collection methods are particularly unfair given that VA relies on outdated methods of notifying veterans. VA's letters alerting veterans of a debt are often confusing and sent to outdated addresses. As one military-connected student who came to VES for help said, I don't believe a human has looked at any of the letters I have been sent. They don't add up or make sense. Semesters are omitted. Figures they quote as to what I owe on one document don't match with figures they quote on a different document. Dates and explanations don't make sense. In sum, we firmly believe VA can do better, and we request the committee's assistance in ensuring this happens. Thank you for the opportunity to present our views, and I am ready to answer any questions you may have.
Thank you very much, Mr. Saunders. I'll now recognize our fourth witness, Mr. Gerardo Avila. Mr. Avila is the Deputy Director for Military Boards and Memorial Benefits at the American Legion. The subcommittee thanks you very much for appearing here today, and you have 5 minutes, Mr. Avila.
All right, thank you. Chairman Pappas, Ranking Member Bergman, and distinguished members who probably serve on the subcommittee, on behalf of our National Commander, James Bill Oxford, thank you for the opportunity to comment on an important issue of the Department of Veteran Affairs overpayment and veteran debt collection practices. It is my duty and honor to represent the American Legion and assist this committee in better understanding this issue, how it impacts our veterans, and provide recommendations for improvement. It is crucial that we address these issues in an effort to ensure that we are not unduly burdening America's veterans with debt as a result of bureaucratic inefficiencies or errors. Every veteran understood that when they volunteered to serve their country, it would come with sacrifice and hardship. What they didn't expect is to be placed in a hardship situation by the very institution who is supposed to be there for them. It is the Legionnaires' collective experience that the creation of overpayments are doing just that. Over the years, VA has made progress in reducing overpayments. However, there is still significant room for improvement. The American Legion last testified before this subcommittee on the issue of VA overpayments and debt collections on May 24, 2017. During that testimony, we focused on the initial cost of debt, communication between the VA and the veteran, the collection process, and the garnishment of an active benefit. The American Legion has seen improvement in several of these areas. Firstly, the American Legion would like to commend VA for taking a proactive role in reducing the dependence claims backlog and initiating new methods enabling veterans to personally update their dependent status via phone, scan, and e-benefits. Due to these efforts, we have seen a reduction of the debt involving dependency claims. Another area of improvement has been the reduction in amount owed due to simultaneous receipt of drill pay and disability benefits. While drill pay remains a large originator of debt at VA, collaboration with the Defense Finance and Accounting Service has reduced the total amount owed. The American Legion is encouraged by these efforts and implores these agencies to continue to work together to eliminate overpayments completely by increasing the frequency which they rectify their accounts. We also encourage that VA has instituted a more forgiving process when garnishing an active benefit as a means to repay a debt. The old practice of garnishing the entire amount resulted in many veterans facing financial hardship. Veterans and their families rely on the monthly VA benefits to make ends meet. While these improvements are a step in the right direction, we have the following recommendations. Internally, VA must fix the lack of integration between the various information management systems. The lack of interoperability results in issues ranging from incorrect addresses to not being able to provide a clear answer on the initial source of the debt. In a perfect scenario, all IT systems will generate a veteran's latest status and most up-to-date information. Additionally, most accredited representatives do not have access to the various systems that VA utilizes. This lack of access makes it nearly impossible for representatives to assist the veteran in navigating the complex and confusing network. In a recent pension case we assisted on, we found that the medical documentation needed had been provided to the VA but had not been processed by the pension center. Since there was no contact with DMC, the amount owed was referred to the Treasury Department for offset. Thanks to representatives, we were able to track down the medical information and provide it to the pension center to avoid further harm. As a result of issues like this, the American Legion calls upon VA to continue to integrate its information management systems and expand access to accredited representatives. The best solution to avoid an overpayment is for VA to immediately be notified when a veteran's status has changed. Information like change in net worth, monthly drill, or incarceration is already being collected by different entities, who in many cases are the first to become aware of this change. The goal should be to develop partnerships with key agencies to ensure critical information is accessible and can be provided to the veteran. In an effort to eliminate overpayments, the American Legion urges VA to aggressively seek out partnerships and collaborate with as many agencies and organizations as necessary to correctly reflect a veteran's current status. The American Legion agrees that if a veteran receives a benefit they are not entitled to, they should have to pay it back. What we disagree with are some of the collection practices used that have resulted in unnecessary financial harm to our veterans. From our recent meetings with VA officials and through our daily interactions with the DMC, we feel that the employees' hearts are in the right place. By implementing our recommendations, the VA will put itself on the path to solving the overpayment issue. We would like to thank this committee once again for the opportunity to testify on this important topic, and I'll be happy to answer any questions.
Well, thank you very much for the testimony of the 4 members of this panel here today and for your dedication on a daily basis to all those who have served and are serving our nation. We really appreciate your advocacy and your presence here today. We'll begin the questioning portion of this panel, and I'll begin by recognizing myself for 5 minutes of questioning. I want to focus in a little bit on the letters that were talked about with the VA earlier and were alluded to you by some of you here today as well. We all know that Congress passed a law that requires the VA to work with veteran service organizations to improve these letters to veterans. We've heard stories about how veterans can receive multiple communications that are many times quite confusing and opaque. So I'm wondering how the VA has worked with your organizations to improve these letters, and do you think the VA has made improvements in recent years in debt collection notifications and in ensuring that these notifications are clearer for our veterans? That's open to the entire panel.
Thank you, Mr. Chairman. The reason it gets so confusing is they always send 2 letters. First, the VA regional office, if it's a debt created by a dependency issue, they'll send a letter to the veteran notifying them there may be an overpayment, and they may owe money to the VA. Then they'll get a separate letter from the debt management center, sometimes 2 to 3 weeks, sometimes months later. And then that letter doesn't provide any information other than, here's how much you owe us, and if you don't take action in 30 days, we'll take your monthly compensation check. So that's the way the process currently works, and I don't believe they've reached out to us anytime soon to discuss any of the new letters. I know that recently VA has shown us letters after they've already drafted them, but I'm not aware of any current ongoing discussions about improving those with the VSO's assistance. Mr. Chairman.
I have seen a report from VA saying that they're working on the standard plain language format that's required by the Veterans Benefits Transition Act 2018. But we talked to all the folks over the VFW who would be invited to these meetings where they would collaborate with us, and none of us are tracking any invitations. So I don't know if they're forthcoming or not, but so far we have not been engaged in that discussion.
No, not on this issue. We have not worked with the VA at all. And just to echo what Shane said, the case that I referenced in my opening statement, I actually saw all the documents that beneficiary got from the VA. She got her initial statement from the regional office laying out why they thought she owed a certain amount of money. And then she got 3 different letters from Debt Management Center that totaled up to $100,000. The first letter said she owed $68,000, so it wasn't even clear how much she owed. Yeah, the process is pretty unclear.
I would agree with the letters. The letters that we have seen were more on the VVA side, notifying when a veteran is service connected, but not necessarily specific to the debt management and the collection process. And I think just to echo on how the debt is created, obviously everyone knows at the regional office, and they're the ones that have the detail, and maybe and they send out the notification. And if the veteran did not get that, then the next letter they're going to get is going to come from DMC. DMC might have limited information. I think this goes to a point about the integration of the IT systems. So if every IT system had the correct information, DMC would not only have a dollar amount, but they would be able to explain to the veteran when they call about why do they owe this amount. And I think nobody likes to pay money back, but if you're given the reason why you owe, then you say, okay, yes, that is correct. And I think veterans would be more willing to pay the debt if they knew the full information.
Well, thank you, and I'm just curious if each of you would be willing to be available to work with the VA on this problem moving forward. If we could just have a yes or no, if you'll make yourselves available to the VA to be consulted about the issue around communications.
Absolutely.
Yes, and we feel it's absolutely necessary.
Yes.
Correct, we will be.
Well, thank you for that. You know, I was struck by many of the examples of real problems that are caused by these debt collections that we heard in your testimony here today. Clearly, these show that just the nature of the problem and the frustration that is felt by veterans and their families causes harm. Mr. Learman, I'm wondering if I could just ask you a little bit about drill pay and disability compensation. I understand that VA is proposing to suspend compensation benefits when it receives notice that a veteran will receive drill pay. Can you speak to your concerns about that specific proposal?
Yes, Mr. Chairman, thank you. The way the current process works with drill pay is the VA will not take any action until they're notified, generally by DOD. If the veteran notifies the veteran, the veteran notifies the VA in advance of their drill pay, then VA can start taking actions and collecting that amount. In the proposal, the proposed legislation that was introduced earlier, they're suggesting that they stop paying the veteran if the veteran may receive drill pay. Without him actually or her being on active duty getting that drill pay, their proposal is to stop the payment the minute they find out they may receive it before they even get it. So our concern is, one, VA is not going to pay them their compensation because they believe that they're getting drill pay. Two, if their drill pay status or their drill changes, which is very common for a lot of people in the Guard and the Reserves, orders change quite frequently, then they won't get an active duty check for that month, nor are they getting their VA compensation check that month. And the VA is proposing to take away the due process portion of that as well. So while they're trying to correct the problem, we think they're creating a larger problem by taking away that due process, and essentially the veteran may not receive any pay for that period from his drill or guard duty or from the VA, and that's a big concern for us.
Okay. My time is up. I'd like to turn it over to our ranking member, General Bergman, for 5 minutes.
Thank you, Mr. Chairman. Mr. Lerman, let's just kind of continue down that road just a second on that question that the chairman just asked. So, as you characterize the details of it, of what they would do, would that be, in your mind, considered be one of those non-technical barriers to achieving a goal, or is that just a way of doing, just a way of doing business? Could we? Is there a way to not do that?
I think, as they reported earlier, if they do more reporting and they do monthly reporting of when drill pay is being paid for veterans who are also getting compensation, I think that's a better way to do it. If we start collecting before they're being paid, I think that's just a horrible way to go and putting veterans in a more vulnerable position than we already are. That was a proposed piece of it was a proposed regulation in April. There's no more comment periods. It's closed. We're just waiting for them to drop the final rule and address all of the comments that were submitted in April.
Okay. Well, again, there's been a suggestion that there are non-technical barriers in a different subject to removing dependents through e-benefits. Do you know what those non-technical barriers are, Mr. Lerman?
I'm not sure what the VA meant by non-technical, but here's how we view this as being real simple. The veteran gets to choose who they receive benefits for. They report their number of dependents. So if the veteran says, I want to remove a dependent, I don't see how that becomes a technical problem or a larger problem on VA, because now they're paying less money out. Generally, when you have to add a dependent, they require a lot of information, birth certificates, marriage certificates, but they've waived all of that in the benefits to allow you to do that instantaneously. So we don't understand what their barrier problem is in allowing them to remove them instantaneously in e-benefits.
Okay. Mr. Fuentes, you got any big events going on this week?
I do have a personal one.
What would that be?
Expecting the first child tomorrow, so
Congratulations.
thank you very much.
That's a big deal. Just remember, you cannot give a baby too much love. It is absolutely impossible. Just try to remember that when they're 2. Now, Mr. Fuentes, on a more serious note here, the situation at hand here, concurrent receipt of drill pay and VA benefits is one of the VA's, the VFW's, top priorities. Do you have any examples of how it affects the average veteran who chooses to continue serving in the Guard and Reserve after they separate from active duty?
General, I served under you, very, very, very far under you when I was in the Marine Corps Reserve.
You were the reason I had a job. My job is to serve you guys.
Thank you, sir. And I'm sure you can relate as much as I did that you can't live off of drill pay, right? And we're using the reserve component a lot more to fight today's wars than we have in previous years. So we need reserve component service members. This is one of the reasons that folks will want to leave, right? So they're either required to forfeit their earned benefits, right, because they're disabled veterans, or work for free. Those are just not viable options. And then on top of that, because of bureaucratic issues, they are now faced with, this. I have an example here: $32,000 in debt that they have to pay at once, or find a way to collect the money to pay for it. That's unacceptable, and our view is that we just need to get rid of the issue by getting rid of the requirement to collect or forfeit VA disability pay.
Okay. Well, Mr. Chairman, and I see my time's about up here. I think it would be a good issue for us to look into, to see, as Mr. Fuentes states, we need to retain good men and women in the Guard and Reserve, especially with all the experience they've gained. And we need to make sure that we're not creating a barrier. Again, there's a cost to everything, but we don't want to create a barrier to long-term retention of good folks. So with that, I yield back.
Well, thank you very much. And if the ranking member would indulge just a couple more questions here before we conclude, I'd like to get a couple more issues out there. And Mr. Avila, just one for you. Your testimony notes that in the first 30 days of the debt collection process, it's a crucial time frame for our veterans to receive protection from garnishment. 30 days isn't really a sufficient time to complete that required action. So what can the VA do to ensure that veterans are able to receive protection from garnishment?
So you're absolutely correct. The first 30, a veteran can request a waiver up to 180 days, but the first 30 days that we mentioned, that's the crucial period to avoid any garnishment and affecting their benefits. And we already know from issues that sometimes the veterans did not receive the notifications, the initial notifications. So we believe and we support a movement to up to maybe 90 days. And this will give the veteran ample time to respond back to DMC and to take appropriate action before any garnishment or possible loss of benefit can occur.
Well, thank you, sir, for that. And Mr. Saunders, one for you as well. Surprised that there's such a disparity between how the VA handles this issue versus other agencies of our federal government, including the Department of Education. And I'm wondering if you can explain how DOE deals with overpayments, and if there's anything that can be, learned from VA in how to approach these issues with veterans.
Thank you for the question, Chairman. The Department of Education pays out their federal education money in stages. They certify that a student's enrolled in the beginning, and then they pay it out after the drop period, and then they have another period at the end of the semester when they pay a final amount of money, and they claw back any overpayments from that final amount that they pay the schools. So they're taking the money from the schools, and it smooths out the process for the students.
Well, thanks for that. And I guess as it pertains to our veterans, that sort of planned out process is a lot easier for them, many of whom are living paycheck to paycheck, just like most Americans.
Absolutely. In the in the add drop period, a lot of people add drop classes, and communicating to people the impact that can have on your benefit, it's unfair to the veteran to force them to take classes that they wouldn't take and any other student wouldn't be forced to take.
Well, thank you for that. General Bergman, I think, had one additional question here.
Yeah, thank you, Mr. Chairman. 5 minutes goes fast, but we got a lot of meaty things here to discuss. Mr. Saunders, in your written statement, you commented that VA should try to reduce the amount of retroactive adjustments for GI Bill payments which amount to VA making a processing mistake and then going back to the veterans to make up the difference once the mistake is found. Why would these veterans not have a case to ask for equitable relief in these situations?
That's a great question, General Bergman. So equitable relief is it's like a final remedy. It exhausts all your future appeals with the VA. It is a way to get it done, but if for whatever reason some situation it wasn't resolved completely, you would prefer the process be handled by waiver. You would want to go to VA's Education Service and have them tackle the problem. That's the preferred way, is to have human eyes on it.
Okay, good. Well, thank you very much, and I appreciate the extra time, Mr. Chairman.
Absolutely, anytime. And I think before we close today's hearings, I just want to thank once again our folks on the second panel here today for your responses and your willingness to continue to be a part of the solution moving forward. And I thank as well the Department of Veterans Affairs for sticking around and for their input on our first panel. Just some concluding observations. I think this afternoon we heard from VA officials that preventing these overpayments is an important goal they're working toward. We also heard from them that providing clear guidance, direction, and support for veterans is another important goal. We also heard from those working with and advocating for our veterans here today that too many people continue to suffer confusion, frustration, and financial harm as a result. VA's testimony did not lay out for us a clear path toward preventing hundreds of thousands of veterans receiving debt notices each year. It seems all too likely that the subcommittee could hear testimony a year from now showing that another $1.5 billion in debt collections is outstanding, which was the same level around the time of this subcommittee's last hearing. I wasn't satisfied wholly with the VA testimony that tried to outline steps for ensuring that the department communicates clearly and effectively with veterans even after new requirements were put into law last year, and I think more work needs to be done there. I appreciate our Veteran Service Organization's commitment to be a part of that. It's worth repeating that the many different parts of VA involved with notifying veterans and collecting debts is a major obstacle getting in the way of reforms. Ultimately, fixing debt management will mean a VA-wide solution. General Bergman, I believe that our staff should work together with the department to address these issues and needs, and I think this should include legislation for any possible new authority and requirements that would help this situation. So, Mr. Ranking Member, I'd like to give you any time you'd like for any closing remarks. Well, seeing none, I wish to express again my appreciation to all the witnesses for appearing here today for your thoughts and views. And members of this subcommittee will have 5 legislative days to revise and extend their remarks and include any extraneous material. So without objection, the subcommittee stands adjourned.
Well done as always.
Rock and roll, baby.